licensing. You know, something very close to our hearts here at the college. But this time we're moving a little bit wider than just New South Wales, which is what we mostly talk about. Now, this is about mutual recognition. A number of things have come up, you know, during lockdown and storms and end of CPD year, and people may have missed it. Now, there's always been the Trans-Tasman Mutual Recognition Act, but that's been readdressed by a number of the states and territories across Australia. And real estate agents are now covered in most states and territories, covered by automatic mutual recognition into other states and territories. So each state and territory obviously has its own requirements and restrictions, which is mostly due to the difference in coverage of the various licence categories. So we all have different licence categories in different states and territories. Good example is in Victoria, an estate agent can sell businesses and rural land to any size, and the sale of livestock's not regulated at all, and there's no such thing as a strata management licence. So there's that estate agent licence that is the one and only. So if you only had a stock and station licence in New South Wales, mutually recognising that into Victoria would be an issue. You would get some conditions or some restrictions put on your estate agent's licence in Victoria. So if you are looking to mutually recognise a real estate licence and you have a New South Wales real estate licence with a sales and leasing restriction, so you want to mutually recognise that from New South Wales into Victoria, you'd most likely be limited to selling property, not selling businesses. And obviously property comes out to include rural land in Victoria. So every situation for every individual is going to be different depending on the current licence categories held by that specific person in their current state or territory. So each state and territory also regulates their licences differently. So if you want to rely upon mutual recognition into Victoria, you won't need to apply for registration or pay any fees. But you would need to ensure that you're eligible to rely on the mutual recognition. So you'd have to read all of that, make sure that yes, you fit. And you must notify the Business Licensing Authority, the BLA, in Victoria of your intention to use mutual recognition to operate in Victoria before you actually begin undertaking any duties or any functions or activities under that mutual recognition agreement. So the states and territories that are currently participating in this automatic mutual recognition process are obviously Victoria, New South Wales, South Australia, Tasmania, the ACT and Northern Territory. So Queensland and WA are yet to join into the process. So, you know, let's wait and see. But there are still other ways of mutually recognising into those states. What you need to do if you're thinking of operating in another state or territory or moving to another state or territory, in addition to your current licensing authority, then you need to check the website for the regulatory body in that state or territory. So if you're going to Queensland, it's the Queensland Fair Trading, or if it's Fair Trading. If it's New South Wales, it's New South Wales Fair Trading. If it's Victoria, it's the Business Licensing Authority, and so forth around the country. You need to get onto that website. You need to search for mutual recognition for property licenses and look at the requirements for that particular jurisdiction. If that doesn't make sense and you can't find it, ring the college. There's a few of us in here that can certainly help you through those steps of looking at where you're wanting to go, why you're wanting to do it, and assisting you along that pathway.